You're someone who, wants to really get a handle on the big issues, right? To understand what's really happening without getting totally bogged down in legal jargon or, the shouting on cable news.
Exactly. It gets overwhelming fast.
It really does. Well, today we're diving into a debate that's both legally complex and super relevant right now. We're talking about the challenges to birthright citizenship in the U.S. and also this intense fight over nationwide injunctions.
Yeah, and our goal here is really to slice through all that complexity, all the rhetoric.
Right.
We want to get to the core arguments, understand the history behind it, and figure out, what the potential impact is of this Supreme Court case that's happening.
Exactly. And we've pulled together quite a bit for you. Legal timelines, news reports, analysis from different think tanks, even a look inside the Supreme Court arguments themselves.
Yeah, we're looking at what everyone say, the president, the justices, legal scholars, commentators. It's a big conversation.
It really is. Okay, so let's unpack this. Starting with, well, what seems like it should be simple, birthright citizenship. But is it really as straightforward as just being born here means you're a citizen?
Well, that's the core of the debate, isn't it? The common understanding, is that the 14th Amendment means pretty much anyone born in the U.S. is a citizen, period.
Yeah.
Regardless of their parents' status.
Right.
But that interpretation is actually facing some pretty significant legal challenges right now.
Okay.
People challenging it are really zooming in on specific words in the 14th Amendment. Specifically that phrase, subject to the jurisdiction thereof.
Subject to the jurisdiction thereof.
Okay, so what do the challengers think that means, if it's not just about being born here?
Their argument is basically that subject to the jurisdiction means something more than just, being physically present in the U.S.
Uh-huh.
They often point back to the 1866 Civil Rights Act, which came right before the 14th Amendment. That act talked about citizenship for those born in the United States and not subject to any foreign power. Okay, not subject to any foreign power.
Right. And Senator Lyman Trumbull, who was a key figure with the 14th Amendment, apparently saw subject to the jurisdiction as meaning something like not owing allegiance to any other country. So it's this idea of political allegiance, not just geography.
Allegiance? That's a different angle. Loyalty versus just location. And I know some legal scholars have really run with that idea.
Oh, absolutely.
Yeah.
You have figures like John Eastman, for example. He talks about a difference between what he calls partial territorial jurisdiction, like you follow the laws here while you're visiting, and complete political jurisdiction. And that, he argues, needs real allegiance to the U.S.
So the argument is if you, say, undocumented or just here on a temporary visa, your kids might be under U.S. laws temporarily, but maybe not under that complete political jurisdiction for citizenship.
That's precisely the argument they're making.
Yes.
And they look to history, to old Supreme Court cases to back this up.
Which ones?
Well, the Slaughterhouse cases from 1872. The court actually mentioned back then that the subject to the jurisdiction part was intended to exclude certain people, like the children of foreign diplomats or citizens of foreign states born here.
Interesting. So even early on, there were potential exceptions linked to foreign ties.
Exactly. And it wasn't just that case. There was another one involving Native Americans that often comes up.
Oh, yeah. I think I read about that. Elk v. Wilkins.
That's the one from 1884. The court denied citizenship to John Elk, reasoning that he owed his primary allegiance to his tribe, not directly to the U.S.
So again, allegiance is key.
Right. And some argue, look, Congress had to pass the Indian Citizenship Act in 1924 to specifically grant citizenship to Native Americans. If the 14th Amendment automatically covered everyone born here, why was that 1924 act even needed?
That's a fair question. It does raise doubts about how automatic it was originally understood to be. But hang on, what about the big one, Wong Kim Ark, 1898? Doesn't that basically settle it in favor of birthright citizenship?
Wong Kim Ark. Definitely a crucial case. The court did rule that a child born in the U.S. to lawful permanent residence was a citizen. No question there.
Okay.
But those challenging the current view say, hold on, that ruling was very specific. It applied to children of lawful permanent residents, people who had, committed to being here legally.
Right, people who were settled here.
Exactly. They argue it doesn't just automatically extend to kids born to, say, undocumented parents or temporary visitors like tourists or students. They also sometimes mention the context of the time, with discriminatory laws against Chinese immigrants, might have shaped how the court phrased things.
So they're drawing a line, a legal distinction between someone here lawfully intending to stay and someone here temporarily or without permission.
Precisely. You have analysts like Hans von Spakovsky from the Heritage Foundation arguing exactly that. He says kids of tourists, students, or undocumented individuals don't meet these jurisdictional allegiance obligations.
And so they should be citizens of their parents' country?
That's his view. And the Claremont Institute says something similar, that citizenship based just on birth location doesn't have a strong historical or constitutional foundation. They think it should be about consent, allegiance, the nation's right to decide who's part of its political community.
And this isn't just academic debate, right? Politicians are weighing in heavily.
Oh, definitely. Former President Trump posted on Truth Social saying, birthright citizenship was meant for the children of former slaves after the Civil War, not, as he put it, for people taking vacations to have citizen babies.
Right.
And Senator Tom Cotton has called granting birthright citizenship to children of undocumented immigrants unlawful and argued it encourages illegal immigration.
Okay. And just to be clear, we're laying out this side of the argument based on their interpretation of the history and the law.
Absolutely. It's one perspective in a very complex debate rooted in specific readings of these texts and cases. It's crucial to understand where they're coming from.
Agreed. Okay, so let's pivot slightly, because this birthright citizenship debate is now tangled up with another major legal fight. These things called nationwide injunctions. What exactly are they, and why the controversy?
Right, so a nationwide injunction, sometimes people call them universal injunctions, is basically when a single federal district judge issues an order that stops a government policy or action everywhere. Not just for the people suing, but across the whole country.
One judge halts something nationwide.
Exactly. And the Trump administration really took issue with this. They argued it was an overreach of power by individual judges.
And this fight over injunctions, that's actually part of the Supreme Court case we're discussing, isn't it? It's not just about birthright citizenship.
Correct. The case currently before the Supreme Court combines Trump v. Casa and cases from Washington State and New Jersey. It directly came about because 3 different district courts issued nationwide injunctions.
Oh, okay.
And those injunctions blocked President Trump's executive order related to birthright citizenship. They stopped it cold nationwide.
So the government's argument to the Supreme Court is twofold. 1, about their interpretation of birthright citizenship, and 2, about whether these nationwide injunctions are even legitimate.
Precisely. Solicitor General John Sauer argued that these injunctions go way beyond the power Article 3 of the Constitution gives to district courts.
Okay.
He also argued they step on the president's toes, infringing on Article 2 executive power. And he made a big point about history, saying these things were virtually unknown for most of U.S. history, like the first 170 years.
Wow, 170 years.
But then suddenly, a big surge since around 2017.
That is a dramatic change. So what are the specific problems the administration sees with these injunctions? Why the big pushback?
They laid out several concerns. First, they said it forces the government to win everywhere, lose just once in one district court, and your policy is blocked nationally.
Yeah, I can see that.
Second, they argued it kind of inverts the whole court system. Usually you appeal up, and appellate courts set broader precedent. This lets one district judge do that.
Right, jumps the queue.
Kind of. Third, they worried it leads to rushed, high-stakes, low-information decisions because one judge might not have the full picture or benefit of other courts weighing in.
Okay.
And finally, the risk of chaos. Different judges issuing conflicting nationwide orders on the same policy. Plus, a DOJ official mentioned forum shopping.
Meaning people pick a court where they think they'll get a friendly judge for a nationwide block?
Exactly that. Picking your battlefield strategically to get that nationwide impact.
So the administration clearly saw these as a major roadblock and potentially a source of legal chaos. And the Supreme Court just heard arguments on all this. What was the vibe? What jumped out?
Yeah, the oral arguments back on May 15th were pretty revealing. Justice Sotomayor, for example, really pressed Solicitor General Sauer.
How so?
She basically argued that the president's order seemed to fly in the face of existing Supreme Court precedent on birthright citizenship and the plain text of the 14th Amendment. And she voiced concern that if lower courts couldn't issue these broad injunctions, what stops the executive branch from just ignoring Supreme Court rulings nationwide?
A fundamental check and balance question. And wasn't there a moment with Chief Justice Roberts during her questioning?
Yes, that got some attention. At one point, while Justice Sotomayor was questioning Sauer and it interrupted him, Chief Justice Roberts jumped in and said, Can I hear the rest of his answer?
Okay. Underscores the tension.
Definitely. It showed how high the stakes felt in the room.
What about other justices? What were their angles?
Well, Justice Ketanji Brown Jackson worried that getting rid of nationwide injunctions might create a catch me if you can scenario.
Meaning
Meaning the government could violate rights and people would have to constantly file new lawsuits all over the place just to stop them. Justice Kagan also pointed out, pragmatically, that look, lots of lower courts had ruled against this executive order already.
Okay, so support for the injunction power there.
But then you had Justice Clarence Thomas bringing up the history again. He noted, the U.S. managed without these things until the 1960s, suggesting maybe they aren't essential.
Interesting counterpoint. And wasn't there another related immigration ruling around the same time?
Yeah. Separately, the court also blocked a Trump administration effort to use the Alien Enemies Act to deport certain Venezuelan migrants.
Yeah.
So, lots happening on the immigration law front.
Wow. Okay, so the justices seem to be wrestling with both the constitutional theory separation of powers and the practical real-world effects of these injunctions. Given all that, what happens next? What are the potential consequences depending on this ruling?
Well, this decision in Trump v. Sass and the related cases could be huge, really sweeping implications. We're talking potentially affecting over 300 federal lawsuits challenging White House actions right now.
Over 300. Wow.
Yeah. If the government wins on the injunction issue, gets them limited or struck down, that would be a significant blow to groups, particularly on the left, that have used them frequently to block policies. It might be seen as reigning in judicial power.
And if the government loses that argument, if the court says nationwide injunctions are okay,
then we could see even more use of them against executive actions in the future, which, could make it even harder for any president to implement their agenda. It could really change the dynamics between the courts and the White House.
either way, it sounds like a major shift.
Absolutely. And the fact the court fast-tracked the case suggests they know how important and urgent this is. We might not have to wait too long for a decision.
Okay, so wrapping this up, we're basically looking at two massive points of friction here. First, these fundamentally different readings of the 14th Amendment, who is subject to the jurisdiction of the U.S.
Right, that core citizenship question.
And second, this battle over the power of lower courts. How much authority should one judge have to stop a presidential action across the entire nation with these nationwide injunctions?
Exactly. Two huge questions. And the Supreme Court's decision, and Trump v. Scarra, is poised to really shake things up on both fronts.
It definitely feels like a critical moment. So here's something for you, the listener, to chew on after this deep dive. Thinking about the history, the 14th Amendment's context, the legal arguments we've discussed, what do you find most compelling about who is truly subject to the jurisdiction of the United States? And then, weighing the arguments about nationwide injunctions, what do you see as the potential long-term consequences, the good, the bad, of either keeping this tool widely available or restricting it? There are no easy answers here, that's for sure, and these debates will definitely continue.